SJC-12661, Commonwealth v. Rahim R. Abubardar.
Foley, good morning, or good afternoon, I should say.
Good afternoon, Your Honor. May it please the court, my name is Thomas Foley. On behalf of Mr. Abubardar, I'd like to thank you for taking this case on further appellate review. The issue in this case is whether Mr. Abubardar was entitled to defend himself as he tried to escape from the van from the sudden and unexpected attack, or is the appeals court right that he was not entitled to do so, that he used force before he tried to retreat, therefore forfeiting his right to use self-defense?
I thought the issue was more a misstatement of, or an increase of the burden of proof, right? Because the judge instructed on deadly force, and this clearly wasn't deadly force.
That's
we can
correct.
get into the retreat part of it, or not. I guess that could control. But I thought more it was, you know.
I think everybody.
Was there a different burden?
I think everybody's in agreement that that would be a reversible error if he was entitled to the non-deadly force self-defense instruction that everybody knows he would have been entitled to, other than perhaps this retreat argument. So it really comes down to the retreat argument. Otherwise, there's no dispute in this case.
I don't think there's an agreement as far as the amount of prejudice goes, right? Because there was an issue on prejudice.
The appeals court, neither the appeals court nor the Commonwealth made that argument, Your Honor. If you've got something specific, I'd be more than willing to address it. It's addressed in Commonwealth versus Basilar. That's the lead case on this, where the court should have given deadly force and non-deadly force, but only gave deadly force. And the court in that case explained why that would be a reversible error in that case, because it just makes it a lot easier for the Commonwealth to win, you know, to disprove self-defense.
So in your view, the issue is whether or not there's a duty to retreat in the vehicle.
Yes, I don't think that this retreat rule prevents him from getting the self-defense instruction. The appeals court, well, they had their first decision, and I'll get to that later if you want me to. The Commonwealth didn't try to make that argument. The appeals court in their second decision went with the retreat argument that the Commonwealth made in their brief. And what the appeals court is saying is that even though the complainant lashed out, all hell broke loose, she was continuously hitting my client inside the van, he wasn't entitled to defend himself because he didn't first try to retreat. He put his hand up and used force on the complainant as she was hitting him before he turned to reach the door, I believe is what the appeals court's argument is. And that argument is incorrect for two reasons. It's incorrect factually, and it's incorrect legally. I'd like to take the legal reasons first, and I really address the legal reasons in my reply brief when I explain why a defendant is permitted to try to protect himself while he retreats. A defendant is not required to put himself in harm's way in order to retreat. There's tons of case law on this. There are jury instructions on this, that a defendant doesn't have to increase the risk to his personal safety. And that's all he did. If you believe that he first used force before he turned to try to get out the door, he was entitled to do that because he wasn't entitled to put himself at further risk by just standing there or sitting there and continued to get hit while he tried to get out of the van as all hell was breaking loose. And I've got a couple good cases.
Factually, from your perspective, which I understand we've got to do for the jury instruction, I'm a little confused about the other two people who are approaching.
Yes.
So when he puts his arms around, when he's got his arms, how does he describe what he's doing?
He holds her off with one hand.
Okay, so he's holding her off. Is he also aware that the two other gentlemen?
Not at first.
Not at first.
Not at first.
Okay.
All hell breaks loose. He puts his hand out. At the same time, I would argue three things happen. He puts his hand out. He says, yo, stop. I'm trying to get out of the van. And he starts reaching for the door. I would argue all at the same time. I don't think the facts show, as the appeals court of the Commonwealth say, that he first did this, then maybe said something, and then turned. I don't.
The puts the arm out is the point in time where the Commonwealth alleges that he was choking her. Right?
The choking, this is a he said, she said case.
No, that's what I'm
choking
saying,
was-
because the witness shows up and sees something, right?
What the witness sees is what my client testified to, not what the complainant testified to. So he's borne out once again, his credibility basically wins out over the complainant. What happens is he puts his hand out, says, yo, I'm trying to get out of the thing, and then there's a knock on the window. And this all takes about 3 or 4
Is
seconds.
his hand on her while he's doing that?
Is he on her?
Is his hand on her?
Yeah, probably in her collar area,
Okay,
trying to
that's-
hold her
that's-
away, yes.
Right, so
Yes.
that's the dispute, whether or not he was trying to hold her off or he was choking her.
No.
Considering the light most favorable to your client, he's holding her off.
No, there's no question in the light most favorable to my client, he was not choking her. That is the complainant's story. My client tells
But
an
that's what
entire...
And they
That's-
didn't
that's
find
just what I
him
just
guilty of
said.
strangulation.
I'm sorry?
That's what I just said. So I know we're looking at this as the light most favorable to your client.
Yes, the choking is out of this case. I'm sorry, did you have a question, just?
No, the choking is out of the case. He was found not guilty of that, correct?
Yes, Your Honor. So
just-
as he's
just
doing
to be
this...
clear, you are, if the jury credited all of his testimony, it is your view that the jury could have found assault and battery based on his pushing of her,
Yes,
and for that, you believe that he's entitled to a self-defense instruction for non-deadly force?
yes, Your Honor. And the trial judge agreed, actually.
And I guess you refer to the transcript. I'm holding her back because I'm also trying to get to the door, reach back to the door if I can stop her from hitting me.
That's correct,
In the
Your Honor.
light
That's
most
one of
favorable
many.
to- in the light most favorable to the defendant, that suggests defending himself while trying to retreat.
Correct, Your Honor. Yes. So to get back to whoever asked about the people walking down the street, he's holding them off, he's telling her, yo, stop, I'm trying to get out the door, he's reaching for the door, and then there's a knock on the window. He thinks it might be these two guys that he's worried about coming down the street. He's still fighting her off. He looks up, he sees two people walking down the street, he pushes her, and then coupled with the knock on the window, coupled with him pushing her away, there's a second, apparently, where finally all hell stops breaking loose, and they both get out of the van. So now even the Commonwealth would have to concede that the two guys coming in the street really had nothing to do with this, because by the time the two guys are coming down the street, he's already reaching for the van. Even the appeals court and the Commonwealth would have to agree with that. The question is, in this 3 or 4 second incident, was there a second or two when, before he turned, was he just holding her off, and is that improper? And it's not improper because legally it's not improper for all the reasons I say in my reply brief, for all the case law that I cite, and for the jury instructions that I cite. But it's also, factually, it's incorrect. Now, my client testifies that he puts his hand up, he's trying to stop her from hitting him, he tries to grab her hand, stop him from hitting him. He says, yo, stop. He's reaching for the door. The Commonwealth, well, the appeals court in the Commonwealth sees this case in the light most favorable to the Commonwealth. They break it down as if there was sort of 10 or 20 or 30 second thing where there was stoppages along the way. This was a 3 or 4 second melee attack, and my client trying to respond to this, which was totally unexpected. So I don't think factually you can say, well, he used force before he reached for the door. I think it all happened at the same time. Chaos breaks loose inside the van, and at the same time, he's trying to hold her off, he's trying to get to the door, and he's telling her, I'm trying to get out the door. So I don't think factually there's any basis for the appeals court decision either. And I've got 2 cases I'd like to talk about that will highlight the difference between my position and the appeals court's position. In Commonwealth versus Franchino, the defendant was walking down the stairs when his girlfriend suddenly and unexpectedly attacked him, apparently. I think the only thing the appeals court really said was that she was set upon him. And the defendant testified that her injuries were a result of him defending himself from that attack. Coming down the stairs, remember, the appeals court, Justice Seifer was on that panel, held that he was entitled to the self-defense instruction. Retreat was not an issue. 2 years later, there's a case where a guy is coming down the stairs, and there's a guy waiting for him with a knife. And the defendant grabs the knife and wrestles with him and ends up stabbing the alleged victim with the knife. In that case, the SJC said, no, he should have retreated back up the stairs. Well, what's the difference between those 2 cases? The difference is, in the first case, the defendant was set upon. He was already being hit. He couldn't retreat. In the second case, in the 2006 case, in Commonwealth versus Vives, he could have retreated because nothing had happened yet. The other guy pulled a knife.
You didn't object to the self-defense instruction, right?
Well, I did not object, the trial attorney did not object to a deadly force only being given. Everybody assumed that self-defense was going to be, well, the judge said, I'm going to give self-defense for the attempted murder and for the assault and battery. In fact, the judge considers it one day, decides to sleep on it, and comes in the next morning and says, I've decided to give it for both attempted murder and assault and battery. So this judge really thought about it, decided to give it for both. The problem is he only gave the deadly force and nobody picked up on it, and that's why we're on a substantial risk. But clearly the judge found that, and the Commonwealth argued retreat below, and the trial judge who saw the testimony, heard the testimony, saw, no doubt, my client acting out what happened, believed him, or credited him, and did not go with this retreat argument that has no basis in fact or in law.
Okay, thank you.
Thank you, Your Honors.
Ms. Black?
Good afternoon. May it please the court, Johanna Black, Assistant District Attorney for the Commonwealth. I'm actually going to start with a position that was of the Commonwealth's that was alleged by defense during this oral argument. I just want to be clear that the Commonwealth does not agree that had a non-deadly force or had an instruction on the use of non-deadly force in self-defense been warranted at the defendant's trial, that the lack thereof created a substantial risk of a miscarriage of justice. And for one, if a non-deadly force had been instruction had been required, it's highly unlikely that such an instruction would have affected the verdict. So even if this court interprets Basler's decision as stating that where a non-deadly force is not given but should have been given, it prejudiced the defendant, this court still has to go on to decide whether not giving it would have affected the verdict. And it's highly unlikely that the jury, on the facts that were presented or the evidence that was presented during the defendant's trial, that they would have found that he had attempted to retreat or that a reasonable means of escape was not available to him prior to him resorting to force against the victim. In fact, the defendant in his briefs argues that there's no doubt the jury completely credited the defendant and completely discredited the victim, but that's not accurate, especially where the jury ultimately convicted the defendant of threat to commit a crime, and the only evidence as to that threat came from the victim's testimony. So where this court, in determining whether substantial risk of miscarriage of justice were to occur, views the trial as a whole, including opening statements by the parties, including closing arguments by the parties, and the evidence that was presented, I don't think you can say that the jury disregarded what the victim said and only believed what the defendant said, especially where, when they were instructed on the lesser included offense of assault and battery, they were instructed on it as a lesser included offense of the attempted murder indictment. And actually, when the trial judge was instructed the jury on this during the charge, he explained that the assault and battery was the lesser included offense of the attempted murder, and that that included within the Commonwealth's indictment against the defendant for attempted murder by strangulation is a lesser included offense of assault and battery. He goes on to say, by this I mean the conduct that may not constitute attempted murder under Massachusetts law still may constitute an assault and battery. And he goes on to say that the Commonwealth needs to prove beyond a reasonable doubt the elements of assault and battery. So where they convicted him of assault and battery, they were instructed on the Commonwealth's burden of proof that the Commonwealth has to prove the elements of attempted murder, and also that the Commonwealth has to prove the elements of...
Isn't that just more his intent?
I think we'd probably be speculating as to what the jury deliberated on and decided.
The distinction, though, right?
I don't think it's the only distinction. So
Here we have an instruction that elevated the deadly force, that incorporated deadly force, that there clearly was none here, right?
I don't think that there clearly was none here. Under Noble, it says that, the SJC case from 1999, it says that hands and fists, although typically non-deadly force, can constitute deadly force, and it's up to the jury to decide. And here, I submit that the jury could have convicted the defendant of the lesser included offense for a number of reasons. One being that the Commonwealth did not prove beyond a reasonable doubt, even if the jury believed the victim, that the defendant actually intended to kill her. And whether we fail to prove that due to mitigation or simply because, such as like a heat of passion, heat of the moment, he's confronting her about being with other men and he's angry and wants to inflict serious bodily injury, but maybe not kill her on her, that could fall under deadly force, but not necessarily attempted murder where he would be lacking the intent to kill her. So I don't think it's completely clear what the jury deliberated and decided on, but I will say that where self-defense is the Commonwealth's burden to disprove, the Commonwealth can do it by disproving or proving that one of the three prongs of self-defense were not met, meaning that the defendant didn't retreat when he should have, that the defendant used excessive force, or in this case, as the instruction said, that the defendant wasn't in reasonable fear of imminent or immediate.
How do you retreat in a car?
You open the door and get out.
That's in that split second, he has got to get out?
Well, the facts show that, and the evidence at trial show that he was on the front passenger seat, and the victim, who, from a photograph that was admitted, I don't think there was any evidence that the defendant was smaller or weaker than the victim. The victim was in the driver's side seat. The car was stopped. There's no evidence that the doors were locked. The victim was not on top of the defendant. She was not blocking his path to exit out the passenger side. She was not, meaning her body wasn't positioned there. She wasn't even grabbing or holding on to him. By his own words, she's just hitting at him or slapping him, not holding him as he was doing to her. So there was no evidence that he couldn't have just opened the door and gotten out. And that, and briefly just on the substantial risk, I do want to touch on the fact that this is different from Noble. And this is different from Baszler. Baszler was not a retreat case. Noble was not a retreat case. Baszler retreat wasn't a contested issue. And here, I'm sorry, with Baszler, factually it's also different. I think this goes to the use of force as well. Baszler testified that he did not strike the victim. He testified that she fell while he was attempting to prevent her from hitting him or slapping him. And that's very different than what the defendant's testimony here was. A reasonable inference from the defendant's testimony was that he was asserting force against the victim. He was pushing her, and he was holding her. He wasn't just raising his arms up in front of his face where he was slapped or his body to block or prevent her slaps or hits or strikes at him. He was going out of his personal space, reaching towards her, holding her, and pushing her, instead of just turning to the other side, opening the unlocked door, and getting out of the car. And defendant makes this huge argument about the law not requiring him to use every means of escape short of death or place himself in greater danger. That precedent isn't applicable to the defendant's case. It's not like the victim, it's not like the gun cases or the dangerous weapon cases where, like this court in Ortega in 2018 said, escape is a less viable option there if you're faced with a gun or even if you're faced with a knife. The cases that defendant cites to show that his, as he says, holding the victim at bay was a reasonable means of escape, those cases don't actually support that argument. Those cases involve dangerous weapons. Harrington involves the victim on top of the defendant. And it actually says, the court actually says he can't reach to the door to open the door and get out. He can't rise up.
So your view is that if the jury credited everything he said, and if indeed his testimony was as described, was that she came at him unprovoked and he was pushing her away, that he'd be guilty of assault and battery for that, even if he was trying to push her away and stop him from hitting him?
Sorry, can you finish the last part about guilty?
If the jury
of assault and
credited all of his testimony,
right,
is it your view that he's still guilty of assault and battery and would not be entitled to a self-defense instruction?
I think if the jury were to credit everything he said, which we don't know that they did, And taking the light most favorable to him, I think there is a possibility that his force would be non-deadly force and he could be entitled to a non-deadly force instruction. I don't think that it would have created a substantial risk of miscarriage of justice in this case because the Commonwealth didn't have to disprove that prong. It could have just disproved the retreat. It could have just disproved the excessive force prong. None of the prongs are necessary or essential elements. As well, he didn't even claim he was in reasonable concern for his personal safety, so the jury may not have even believed or inferred from his statements or testimony that he actually was concerned for his personal safety. And again, the Commonwealth still had to prove that he was not justified in assaulting and battering the victim. So even if he should have gotten a non-deadly instruction and the jury was given this instruction on deadly force, which they were never told was deadly force, they were never said the defendant used deadly force. But they could have very well just found that instruction didn't really fit the facts, and they still would have had to go on to decide if the Commonwealth proved that it was an unjustified assault and battery. So I don't think the absence of the use of non-deadly force instruction in self-defense in the defendant's case and the absence thereof created a substantial risk of miscarriage of justice.
All right, thank you.
Thank you.